This video will explain copyright in dramatic works by reference to the cases of Green against Broadcasting Corporation of New Zealand and Nine Network Australia Proprietary Limited against the ABC. Copyright can subsist in four categories of original works. One example of an original work is a dramatic work. Like other works, they must be reduced to writing or some other material form before protection arises. A dramatic work is not exhaustively defined in the Copyright Act, but it includes a choreographic show or other dumb show and a scenario or script for a cinematograph film, but does not include a cinematograph film itself. Essentially, a dramatic work is a work that is intended to be performed or represented. The work must have sufficient unity. This means it must sit together as one piece, as opposed to a jumbled mix of random and unconnected elements. The cases of Green against Broadcasting Corporation of New Zealand and Nine Network Proprietary Limited against the ABC will help to understand these concepts further. In Green, the appellant was Mr. Hugh Green, who was an author, producer and host of a Talent Quest television program called Opportunity Knocks that aired in the United Kingdom from the early 1960s until 1978. Mr. Green claimed ownership of copyright subsisting in the dramatic work of the format of the show. He argued this was infringed by the respondent when they aired a show with the same features, such as the use of certain catchphrases, the use of a device called a clapometer to measure audience reactions, and the use of sponsors to introduce contestants. The Privy Council unanimously upheld the majority decision of the Court of Appeal of New Zealand. Lord Bridge concluded that when looked at as a whole, the dramatic format of Opportunity Knocks was lacking in sufficient unity to amount to an original dramatic work. This is especially because the performances changed with each edition. The features making up the format of Opportunity Knocks were unrelated to each other except as accessories to the presentation of the changing performances featured in each separate show. The format was the skeleton framework of the show's content and lacked unity as a whole to make it an original dramatic work. It merely provided the basic idea of a talent show, which cannot be protected by copyright. This case tells us that a dramatic work will not subsist in the format of talent, quiz or game shows. This is because features making up the format of such shows cannot be isolated from the changing content presented in each separate episode. Nine Network Australia Proprietary Limited against the ABC concerned the firework display that was planned for Sydney Harbour for the Millennium celebrations. The Nine Network, who had an exclusive right to record the event and televise its coverage, applied to the Federal Court of Australia to restrain the ABC from broadcasting the event. The Nine Network claimed copyright subsisting in the public firework display event as a dramatic work. The dramatic work was argued to be in a material form of the schedule that detailed the particular fireworks production. The dramatic work was said to exist in the ultimate production alone or in combination with other events occurring on the harbour. Although Justice Hill did not need to decide the issue, he did observe that if the applicant were to go to trial, it would likely have difficulty proving that the ultimate firework display would adhere to the planned schedule. This is because a fireworks display is chaotic, and it would be unlikely that it could be reduced to a precise planned schedule. Even if it could, the random and unconnected display could hardly be said to have sufficient unity required to make it a dramatic work.
Created using Powtoon.